Yes, good afternoon to everybody. Welcome to the today class of this last set, not last set. This is their taught remedial classes for those who are preparing for the on 27th of this month examinations. Yes, before I could go further, let me ask the participants whether you could see my screen or not. Yes.
Same, sir.
Yes. What I cited on the screen.
Good morning. Where there is light, there cannot be darkness.
Yes, where there is a light, there cannot be darkness. See that education, knowledge, these are all the things that are very much necessary to make the man to awaken. So yesterday that I was discussing about the general defenses and receps equitar also I completed it. But in this class, I told you that I posted today will be the distinction between the tort and crime and the distinction between the tort and contract. Later on, the time left over there, then we can go to the demnum sine injuria and injuria sine demnum. These are the things which I want to discuss today. But I told you that if any one student also there, that I will continue my class, I will keep the spirit, and those who get the benefit of it, let them get the benefit of it. Okay, distinction between the tort and crime is concerned. As we know, the torts are legal wrongs against the individuals. For instance, malicious prosecution is a legal wrong, defamation, assault, battery, and whereas a crime or wrongs against the society punishable by the state, for instance, murder, robber, and rape. But in one way, we can say that torts are civil wrongs which connected to the individuals. The example which I have given here, malicious prosecution, defamation, assault, and battery. But whereas matter comes to the crimes are concerned, it is against the society and punishable for the state. For instance, murder is there, robbery is there, rape is there, dacoit is there. These are the public wrongs. The second distinction we can say torts award the victim of the compensation. So in the tort, generally the people go to the court for getting the compensation, that is the damages, whereas the crimes imposed a wrongdoer, the punishment is more important factor over there. Of course, in addition to the punishment, they are also imposing the fine also because of the jurisprudence. You changed over there for the punishment. In addition to the punishment, there will be some monetary benefit also being given to the victim. So that the new concept is there. So incarceration or imprisonment or sometimes fine also be there in the crime. But in tort, major it is the damages is awarded over there. Yes. Can you read the number 3? Anyone?
Torts are pursued as suits in courts of law by an individual, where crimes are moved by the state as proceeding which is public wrong.
Yes, the third it says tort is a individual things and a suit will be filed in the court of law by the individuals, those who are got the victim or those who are got in one way in another way that we can say the victim of the wrong of another person, and where the matter comes to the crime is concerned, it is a proceedings which is public wrongs are there, it is moved by the state. So we can say generally it is a tort is moved by the individuals and the crime is moved by the state. That way we can make it out. Yes, come to the matter of the torts are number 4. Torts are mostly generated by the court. There is the negligence, deceit, nuisance, and the crimes are created by the parliament in the form of the statute or act. In the case of the torts, it is mostly the individual will generate such an offense, like a negligence, disease, and nuisance. But in the crimes, it is made by the parliament in the form of a statutes. So that we can say these are the things which are crime, like a murder, rape, dacoity. They are the numbered over there in the IPC. That's why we can say it is a crime. Okay. Number 5th, the object of a criminal law is to protect the right. So the criminal law, the object of the crime is that to protect the right of the person, and whereas the object of the civil law is to protect the interest of the person. In the civil law, that is the tort law, that individual interest is protected over there, but in the crime, it is a criminal law, that is the right will be protected, that of the masses. Okay. So number 6 is concerned in tort, the law of limitation is generally 3 years. The limitation period is there 3 years. In general, as far as the Motor Vehicle Act is concerned, I believe that is 1 year. Within 1 year that you have to file a case, subject to the correction is concerned. Whereas the crime law of limitation may not apply over there. But in the crime, generally that once the crime is made it over there, generally it will be given the complaint to the police. So the law of limitation period will not be fixed over there. Generally, we will say, but when the tort is concerned, limitation period is generally 3 years. Yes, number seventh is most of the tort law is based on cases, and that's why that generally I say in the class, tort law is nothing but, tell me, tort law is nothing but, yes,
Sir.
multiplication of the case laws,
Okay.
or tort law is nothing but product of the case laws. No
Okay, sir.
tort law, no cases, no tort law. So most of the
Okay, sir.
tort law is based on the cases. There's the precedents, decided cases. There is the judgment law, and the crimes are concerned generally based on the section of this statute. So the section of this statute will say that is a crime. What's the murder section in the IPC? Just for the test, I am asking you.
Oh, sir, IPC 300, sir.
307,
Uh,
sir.
yes, yes. Tell me.
Attempt to murder.
Attempt,
Three.
sir,
307.
murder is an 300, sir.
See, the definition of the murder is given in the 300. If I not mistaken,
Ah,
302 gives the punishment is there, and the 307 is saying that it is also is an attempt to murder or the intention to create the murder, something like that. So
okay, sir.
420 everybody knows. What is 420?
Cheating, sir.
Cheating is a 420 over there. So these are all the sections are there in the crimes, but in the tort law there is only the decided cases. The eighth distinction there is no stigma in tort on the wrongdoer, but whereas in the crime there is a stigma on the wrongdoer. Here stigma means blemish. మచ్చ అంటారు చూడండి తెలుగులో.
And
So that is a stigma is there in the tort law of the wrongdoer, but whereas in crime there is a stigma. In the tort law there is no stigma. Means what is there? Is you create the nuisance or you create the malicious prosecution, you pay the money and you can become a scot free, and there is no such a stigma would be there in the tort. But whereas matter comes to the crime is that there is a stigma. Suppose if a person has did a rape, then he is called a rapist. The stigma would be there. If a person has murdered somebody else, then you call the murderer, we can say, then the stigma would be there. So that is a matcha is there, and the people will try to avoid them such a cases. When the tort law, there is no such a stigma. Now let us come to the ninth point is concerning tort. The proof or the evidence is based on the propensity. So always the proof is there in tort on the propensity of the evidence. And in the criminal law, proof of evidence is beyond a reasonable doubt. So when the beyond a reasonable doubt would be there, then we can say it is a crime. It will be followed, but a propensity of the evidence would be there in the tort law. That's why we say what is the saying is there. Let 99 culprits will be acquitted, but one innocent cannot be convicted.
punished.
So that's why that is called beyond the reasonable doubt in the crime. But in the tort law, that will say propensity of the based on the evidence they can decide it. But the 10th distinction is where it is the tort age is not a criteria, but in crime, minor is exempted from certain offenses, especially their age factor is concerned, or mental maturity is concerned, or the guilty mind is concerned. Even the contract also minor will be exempted over there because minor means he doesn't have the maturity of the mind, and hence he could not know the nature of the act what he is doing, and hence the exemption would be there. And that's why they say a minor will sit on the lap of a judge. Lap, L-A-P, lap ante toda. On the lap of a judge means thigh. So the judges are the maternal uncle of a minor. So in one way, in another way, the people says means such a protection would be there in the contract as well as in the crime also. But where in the matter of the tort is concerned, no, 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 no. If a person did with the intention or without intention or whatever way the cause might be there, and if a damage is happened over there, yes, the father of the boy should have to pay the compensation in that regard. Suppose if a boy has when playing the cricket or throwing the stones on each other, the one stone has hit the car windscreen, the front screen. At that instant, the car screen is broken over there. At that instant, the father of the boy who did such an act would be pay the compensation in that regard. Though there is no exemption of a చిన్నపిల్లగాడే కదండి పోనీయండి So in Telugu, that is say, but a small boy will know, let it go, because he doesn't know the act what he is doing. Okay, he doesn't know the act what he is doing, but you know the act what he is doing, you pay it on behalf of him. So then generally a child will be identified with the father. That's when the father will come to the rescue of the person and who got such a damage. Yes, next, that is the age factor is concerned. There is no age factor for the tort, but the age factor may be considered in the crime, because generally we will say a person below the age of the 7 could not commit a crime. Do you agree? Do you agree? Say yes or no. Yes? Sir, we don't know, sir. Yeah. If the below the 7 years, generally that he doesn't know the nature of it, he doesn't have a guilty mind over there. Then the exemption would be there. Only from 7 to 12, when he know the maturity would be there, then he will be punished in the juvenile courts. Okay, let us come to the 11th point. There is a vicarious liability in tort, but there is no vicarious liability in crime. And a vicarious liability here is, suppose if a child did such an act, then the vicarious liability would be there on the father to pay the compensation. If an employee did such an act, an offense, as which is a tort, which is a civil wrong, then the employer should have to pay the compensation, because under the vicarious liability. Suppose you are the owner of the bus car, and where your what is a driver is driving the car, and a driver is an employee. At that instance, that for driver negligence, the master is held liable under the vicarious liability, because there are certain relationship would be there when you want to apply the vicarious liability in the tort, but there is no vicarious liability in the crime. The reason is, suppose the son has did a murder or a rape or any other thing is concerned. Can you keep the father in the jail? Yes.
No.
No, sir.
Answer is no, because there is no vicarious liability in the crime. But the vicarious liability in the tort is there. That is the 11th difference. We can find it out. Then the 12th difference that we would want to make it out here is tort looks to the victim. And restoration of the status of the victim is the purpose of the tortious action. But in the tort, what will happen? Suppose if a person got injured, let me presume that his leg was fractured. But whatever the expenses would be there, medical expenses and attendant expenses and medicines and his dependents and whatever when he loses some salary also, that expenses also compensated to the person till he restored it back the original position. So that is the basic idea we can in the tort law. But the criminal law looks to the accused and see that the accused should not commit to such a offense again. In the criminal law, what will do? No, they will not allow such a person to do commit again such a crime. For instance, suppose if a murder is done committed by a person, so what will happen? Of course, a trial would be there. Then he will be sentenced and he will be put behind the bar. Why he will put behind the bar? Suppose if he is free, again he does the murder, because he knows that one murder also same offense and the same punishment. Two murders also
M.
same the thing. Then of course magnitude will be increased over there. So here they will not allow the person to go out. That's why the imprisonment will be there in the criminal law. But in the tort law, they will see that the person should have to restore back its original position, as if um, the accident will not occur, the injury not occurred, uh, in that way that it can be compensated. The tort is concerned. And next, so we will see the chart, because I have given the chart. But when you are writing in the examination, please keep in the mind, you also make the tabular chart like this, what I have shown over here. You can write here left hand chart or right hand crime or whatever is manner. But generally, suppose if you write in the examination the distinction between a tort and a crime, better you start with the tort. Don't start with the crime. Okay? So here, let me make it out. If you are a crime and tort, that same thing I put it in your one line or two line. So in the crime, they say a crime is a wrongdoing which hampers the social order of the society we live in. Because in the earlier that we note, a crime is against the society. A crime is against the public. A crime where the public at large will be suffered. That is an idea about the crime. The tort is a wrongdoing which hampers the individual or his property. only one individual or the property will be hampered over there, then we can say tort. When the people at many would be hampered over there, or God, the social disorder would be there, at the times we can say it is a crime. Is it clear? Say yes.
Yes, sir.
I appreciate. I appreciate. Okay, next is crime happens mostly intentionally, and it is a deliberate act which people do it to get some unlawful benefits. So here the crime happens. It is an intentional the act. People have some intention only, and they will commit it. Either for the sexual gratification is concerned, or the monetary benefit is concerned, whatever that matter, it's a crime. But it happens in the tort. It is happened because of the negligence. Suppose an accident happened, is it an intentional act or is it an unintentional act accident? Sir, sometimes intentional act also. I say sometimes, but mostly accidents are, yes, accidents are unintentional act. Are you following me? So here,
Yes,
but the crime is an intentional act and the tort is an unintentional act because there is no intent. It happens due to the negligence of a person. Negligent he will be there and it damages the individual. That is the negligent act mostly placed in the tort, but less intention will be taken into consideration. But the crime, intentionally they did it, that's why we'll say the guilty mind. Okay. Crime impacts the well-being of the society in general. The legal bodies, they try to give the proportional punishment to the law offenders in order to maintain the peace in society. See, in the crime, the person who did that is called a perpetuator, he will be put behind the bar so that he will not repeat such a crime again in the outside. So that is the impact well-being of the society in general. So that's why society want to be in a peaceful manner, that the criminals should be put behind the bar. సార్ వాళ్ళ చంపేస్తే సరిపోతుంది కదా నో see we have to give a chance to one man at least, not that because when you hang to death also they will ask you, may what is your last desire, they will ask you, is it or not?
yes, sir.
Yeah. So a chance would be given over there. That is a crime, and but the tort impacts well-being of the individual. The aggrieved party seeks compensation for the damage. In the tort, what will happen if an aggrieved party would be there? Okay, you pay the some amount, and you see that he will be restored back its original position. That much is enough in the tort. Next point is the crimes are presented in the criminal court. Okay, where the torts are presented in the civil court. Because tort is a civil wrong, naturally the civil court would be there, and the crimes is the criminal wrong, and the criminal court is there. Sir, there are two separate courts. Yes, and sometimes there are separate courts. Or the district court, when they deal with the civil cases, it say district court. When it deals with the criminal cases, it will say the sessions court. Repeat? Anyone?
Yes, sir.
Repeat? Repeat what I said.
Torts are in civil courts, sir.
Okay.
Crimes are in district courts, sir.
No, I said like this. If the civil
Sir,
cases are dealt in the district court, we can say district court. When the criminal cases are dealt in the district court, we will say sessions court.
ah, yes, sir.
That's
Okay,
I
sir.
told you. Sessions court means criminal cases will deal. Court is the same, district court. But when it deals with the sessions, when it deals with the criminal, you can say sessions court. That's why you could see it, no? District and sessions court will be written over there. Have you seen the board? District and sessions court, it will be given over there. Because when you deal with the civil cases, it is a district court. When it deals with the criminal cases, it is a sessions court. Okay. Next comes to the next. Compensation for the crimes is already mentioned in the book of law. And whenever, wherever the court is to decide the amount of the compensation, they simply refer to the law of the books. In certain cases, judges use their personal judgment too. In the crimes, especially, punishment is clearly mentioned over there. But even sometimes punishment and fine also mentioned over there. And a fine how much depending upon the nature of the offense which it is. And sometimes it will be very much specified over there also. But when the comes to tort, it is not specified. Compensation will be calculated, assessed. For instance, if a bed earning person is died over there, then their assessment would be there. Suppose if such an accident will not happen, how many years that he is supposed to live it? Longevity period. Multiplied theory would be applied over there. How many dependents are there? They will see it. And what are the chances of becoming an officer later part? They will calculate all the slats, then they will fix the how much the compensation should be paid. Suppose the breadwinner is no more over there. So compensation for tort is given in the basis of the damages to the aggrieved person. So the aggrieved person, how much it is paid over there, they will calculate it and they will give in the tort. But whereas in the crime, it is specifically mentioned how much the punishment would be there and how much the fine also should be imposed. Yeah, tort and breach of contract, let us see it. Now, just now that we did it, there's the tort as well as and the crime, what is the distinction between them. Now we will see the distinction between the tort and the breach of contract, or we can say a contract. Okay, in tort law, the duty arises from or through the operation of the law, and it is imposed against the whole world. That is the right in rem, we say. Where in a contract, the duty arises from the agreement of the particular person, and it is a right in person. So, in the tort, one should not injure another person. That is the operation of law. Suppose if he caused an assault or a battery, whatever it may be, at that instant that he committed an offense. So it's the operation of law, it is there in tort law. But in the contract, the two parties will agree together and they will make the terms and conditions. So that's why we say tort is right in rem and contract is right in personam. Personam means particular persons, those who are party to the contract. So that is the first point, we make it clear. Let us go to the second point, limitation period for 3 years for the first schedule in part 1, that is in the law of tort. The limitation period of the Act of 1971, where there is 6 years as per the Law of Limitation Act 1971. So in the tort law, 3 years limitation period. In contract, 6 years limitation period. Is it clear?
Yes, sir.
Can you repeat?
In tort law, 3 years period, sir. In contract, this is an 6 years period, sir.
Yes, that is only the thing that you can make it out. But when you write in the tabular form in the examination, that is very impressive. You can save your time also. Yes, in the third, in awarding the damages or forcible test is applied, whereas in a contract, the loss which arises naturally and which was within the reasonable contemplation of the parties. That means, in the damages in the tort, forcibility test also will be taken into consideration, whether it is going to be happen such a thing or not. Suppose if they are not going to happen such a thing, means no damages will be awarded over there. And in the contract, there is no such a forcibility, and they will say that within a reasonable contemplation, what will be the agreement of the party, then the damages will be or penalty will be awarded over there. Number 4, tort for unliquidated damages, and whereas contract for the liquidated damages. Then what is liquidated damages and what is not liquidated damage? Unliquidated damages means, a liquidated damages means it will be clear cut mentioned, and how much the penalty or the how much the amount will be fixed over there, that is determined, means prefixed or ascertained before the contract itself, and before the breach of contract occurs, that already ascertained amount is said to be the liquidated damages. That is there in the contract. But unliquidated damages, only damages are happened over there, then they will calculate it, the slots, how the assessment of the damages will be there, which is not certain in the period. Like suppose if I slap you, I will give 10 rupees. If the two slaps are there, I will give the 20 rupees. Such a fixed amount would not be there over there. And if you got slapped over there, there is an insult on him, number 1, defamation, number 2, number 3, there is a battery also. So all these slots will be booked over there and filled over there, then the assessment will be made. That's why we can say it is not the fixed amount or a sustained amount would be there in the tort. That's why we can say unliquidated damages. Is it clear?
Okay, sir.
Number 5th, in tort, the other party, whoever, either he or she, maybe, who are unknown till the wrong committed where. See, the other party will not known in the tort. Suppose the accident happened. Of course, driver is there, no doubt. Lorry driver or bus driver or car driver. Who is the other party? Unknown.
The plaintiff is the other party, sir.
But whether the plaintiff will be known other party in the beginning? Unless until accident takes place. Only accident takes place, the other party would be known.
That is a victim, sir.
That is the victim will be known when? After the accident only.
Oh,
Can
yes,
you say
sir.
that Rama is a victim? No. Krishna is a victim? No. When he
No,
got
sir.
injured over there in the accident, we can say is a victim. That is the reason the other party, whoever he is there, or he or she, maybe who are unknown to till the wrong committed. Till the wrong committed, they will not know who are the other party. But whereas the contract part is known, and the stranger to the contract cannot be sued. In the contract, there are the agreement between the two parties. So parties will be known. And the terms and conditions are also there. And if the default, if the breach of the contract is there, there also be a certain amount will be fixed. That's why we'll say liquidated damages. But a stranger to the contract cannot be sued. Because if a third person would be there who is not party to the contract, he cannot be sued. That is in the contract. But in the tort, no, even sometimes, there is no such a party would be there, but a third party also can sue it. For instance, I will give you an example. There is a contract between a father and a doctor to do the operation to a minor son, a boy or a girl. Suppose if there is a negligence in the part of the surgery or operation, at that instance, father will file a case under the contract, and the child will file a case under the negligence in the tort. So even the child is not a party to the contract, but still he or she can file it. So that provision is there in the tort. But in the contract, no. Only the parties to the contract could be sued. So that is the distinction we can see in the fifth. Now, come to the sixth distinction is in tort, the punitive damages are awarded, but punitive damages are not available for the breach of contract. Here, the punitive damages means it is a damage which will be imposed like a punishment. In other words, we can say exemplary damages. Suppose the damage is 10 rupees, but the court will fix even 40 rupees also, because the wrongdoer, you should not commit such an act once again. That's why the 4 times high, instead of 10 rupees, they will make 50 rupees, means 4 times high, 10 plus 5 times high, means 10 into 5, 5 times high, they will make it 50 rupees. Suppose the 40 rupees is there only 4 times, for that they will multiply it. Why they multiply it? It is to punish that man so that he could not do such a thing again. That's the reason exemplary damages are awarded in the tort, and no such a punitive damages will be there in the contract, where the breach of contract occurs over there. Is it clear?
Clear, sir.
Yeah. Now the seventh question is, not question, seventh point is, stranger to the contract cannot sue. That is clearly mentioned in the contract 1, Dunlop Pneumatic Tires Company versus Selfridge and Company. There it is clearly mentioned the stranger to the contract cannot be sued. But in tort, there is no reason why same set of facts give rise one person right of action in tort, though not in the contract. A stranger can sue under the tort negligence in the Class-17-09-2021 Bachar versus East India Hotels. Suppose the pilot was died over there, but still the pilot wife and children can sue it in the Class-17-09-2021 Bachar versus East India Hotels Limited. This is a French pilot case law, where he dived in that hotel from the diving pad or the level, and directly hit to the bottom of the swimming pool. Then he became a
Swimming pool.
tetraplegic. So that is the case law would be there. And in that, if he died also, then children will make a compensation. But in the case law, that is made very much clear. Already that he paid the money, and the lot of amount is paid over there. Then once death is there, nothing is there, because already that whatever the amount that he They want to pay it, they paid it already. That's why the maxim is applied over there in this one. The maxim is actio personalis maritam cum persona. The personal action dies with the person. So that also made it very much clear in this case. Okay, in the Donaga versus Stevenson also, he is not a party to the contract, but still, and he can be sued in the tort. The reason is there is a negligence on the part of it. So that will be the point where we can say the privity of contract. Then we will say in certain cases, privity of contract is a fallacy in the tort, but generally the privity is taken into consideration in some cases. But privity will be counted when there is a person who is a beneficiary. At that instant, he can file, even though he is not a party. Of course, that is also we can make it out as a distinction. Now let us come to the eighth one. In tort, there is no agreement in both the parties. Yes, I will slap you, I will pay you 10 rupees. Is such an agreement would be there? No. I will
No,
make
sir.
an accident, I will pay you the amount to you. Such an agreement would be there? Answer no. So in tort, there is no agreement between the both the parties. The law imposes the duty to act with the caution when it is possible to injure the other, cause the injury to another person or property. So the law will impose a duty on certain person because nobody could beat another person, even the wife also. Because the common law says you can break a wife's wrist, but you cannot break the wife's wristwatch. That's the common law principle. But now, neither you can break the wristwatch nor can they break the wrist. Are you following me?
Yes, sir.
So, when it is possible to injure the other, there is no agreement between the party in the tort. But here, there is an agreement would be there. If a breach of contract comes over there, okay, this much is the penalty. But in a contract where both the parties agree on the same things, the terms and conditions are there. That's why that we say is an agreement, and that is why we can say it is a contract. So ninth question that is yes, ninth point, not question. So ninth point in tort, time of limitation starts from the occurrence of the damage, but it is a contract. Time of limitation begins from the breach. So in the tort, when the occurrence of the damage is there, from that day onwards, it will be counted. But in contract, it is a limitation. The time of limitation begins means it will start when the breach was made. When the breach of contract is made, from that date will be taken into consideration in the contract. Damages in the tort and the breach in the contract. The day. So that is the ninth one. Come to the 10th one. In a tort, mental element is sometimes taken into consideration. Of course, sometimes mental element will be taken into consideration in tort, but in the breach of a contract, a mental element of such a breach is immediate. Whether he is having such a mental element or not, no. Whether he breached it or not, that is the point to be taken into consideration. But in generally tort, they will say that whether he is having such a mental element or not, that will sometimes, I say sometimes, will be taken into consideration. Otherwise, it will not be taken into consideration. So these are the things which you want to make it out. Of course, ideology, leaders. So this is the different. So now we will see made the difference between the contract and tort. Also, we did it, and what is in contract and what is in tort, and how it can be dealt. Is it not? So that
Yes,
we
sir.
dealt, but let us see whether there is a table or not. If the table is there, then more better we can go to the table. It's a very good point. Yeah, there is a tabular form is there. Okay, let us see the table so that it is easy to remember it. The characteristic, contract and tort. Meaning, when you see the meaning, it is a contract is a set of laws the law can enforce. Means set of rules and regulations agreed by the parties. But when you come to the tort, the set of legal remedies entitling a victim to recover from losses or injuries or damages. Suppose if any injury is caused over there, if any breach, if any violation of the duty is there, when a person has suffered over there, at the time that he will be compensated. The injuries were compensated from the wrongdoer. So rights and obligations, let us see how the rights and obligations in the contract. In the contract, rights and obligations result from the acts of the agreement between the parties. So if the agreement between the parties would be there, these rights and obligations will arises. But there is no such an agreement would be there in the tort. The result from the common law are created by the court. Either the law-abiding citizens, or it is by the created by the common law, or it is by the statute. It will be created over there, such a duties in the tort. What are the duties should be there? In the parties determine the duties. So the duties is determined by the parties only. They will agree together. But here in the tort, law determines the duties. The law will determine whether the duty is there or not. See, I will give an example, then I will ask you. Suppose if your son, you sent for the swimming pool for the learning swimming. Okay?
Okay,
There is
sir.
a coach also. Means the swimming coach means who teaches swimming to the students, that is a coach also there. Suppose if any student while he is swimming will, what I say, if he could not make it out, if he drown over there, at that time it is the burden lies on the duty lies on the coach to save him. Okay,
Oh, sir.
this is one scenario. The another scenario is there in the villages. There is a pond. In the pond, students will, of course, boys will they swim over there. If one boy is going to be drowned over there and the people are crying, please save that boy, save that boy. And if you are a passerby, is the duty lies on you to save the boy?
Oh, it is a duty, sir. It is a moral ethic.
It is a moral duty, but it is not a legal duty.
Oh, yes, sir.
Suppose if that person who doesn't know the swimming, what will happen to the fate? Both will die.
He will be died, sir.
So a moral duty would be there, but not the legal duty. But for the coach, it is not the moral duty, it's the legal duty would be there for the coach. Because the coach is there to teach the swimming to the students, number one. Number two, if anybody is drowning over there, he try to save such a student. It's a duty, that is a duty.
Yes, sir.
Minors, when you come to the manner of the minors are concerned, and in the contract, the limited liability would be there, minor. For instance, we have seen the case law, I think it is the Nash versus Iman. That was the case law where the three-piece suit case law. So if you are supplying the necessaries to the minor, it can be, we can get the contract is valid, or we can get the its money. Suppose if you want a three-piece suit is the fashion. Suppose if he's really having all the three-piece suit and he's having the sufficient suit, but still if you stitched a three-piece suit to him means that is an extra. That is a basic necessities. If you supply to the minor, yes, you can get the
Yes.
money. I say basic necessities. Sir, ice cream or ice cream ichindu, sir. Whether the ice cream is a basic necessity.
No, sir.
Suppose if you are given the water, yes, water is the basic necessity. So he can get it. There he cannot say that I am a minor, so minor contract is void. So that is the minor, that is the reason. The limited in liability would be there in the contract, and in tort can be sued and damages recovered from their property. There is no such a minority. అయ్యా మా చిన్నపిల్లగాడే కదండి, ఆ కన్ను పొడిచిండు, కన్ను పోయింది, ఏమన్నా చిన్నపిల్లగాడే కదా. If a small boy is there and he pierced into the eyes of envy, then okay, he will say 100 times, excuse me, బిడ్డ ఒక 100 సార్లు excuse చెప్పు. Can you say that the son or daughter, you say 100 times excuse to her? Or she lost the eye, the other point. You will be compensated. You did not say minor. So there is no minority in the tort. Privity. Privity does not exist, nor is it needed. So here privity means closeness, party to the contract. Actually, privity means whether they are the party to it or not. Privity does not exist, nor is it needed. And here privity must exist. In the tort, even though he is not a party there, like I told you, there is a contract between the father and the doctor for the operation of his son, and who is a minor. And at that instance, in the contract, father will file a suit under the tort. Even though the son is not party to the contract, he can file a suit against the doctor in case of the medical negligence. Okay?
Okay, sir.
So these are the ideas should be there, and where I made it out. Of course, again, there are certain things. The same thing would be put it in the form of the points, and you can write in a tabular form. That is very much important factor, and in the examination, so it is easy to the examiner to see whether you have the knowledge between the tort and contract or not. By looking at the table, he can make it out. The same, the repetition that I made it out. In tort, no privity exists or needed. Harm is always inflicted against the will of the parties injured. That is never heard. But in the contract, there must always exist the privity of contract between the parties, and the parties must be legally bound to each other. Like a Dunlop pneumatic company versus a Selfridge company, where a stranger to the party cannot be sued over there. So that is the privity is there of contract between the parties is a must there. The second point again I will repeat it. In a case of tort, minor can be sued for damages are paid out of his property. Yes, a minor can be sued or can sue also on behalf of his father or behalf of his legal guardian. And when the comes in the contract, minority is a good defense here, and minor contract is wide in ab initio. And the best example in the contract, you will see that what is the case law? That is the classical case law. He mortgaged the property, he has taken the amount, but later on he did not pay it, and he filed a case. Then the defense is taken by the his minor's contract is wide in ab initio. What is the landmark case law that is? Can anybody will tell in contract? Yes.
Sir, pass on, sir.
Mohri Bibi versus Dharmadas Ghosh.
Yeah. One
That
second.
is the landmark case law where we can say a minor's contract with white. Number three, a tort is inflicted without or against the consent of the party. The obligation arises without any consent. There is no consent would be needed over there. Without against the consent of the party. And but in the contract, consent is must. Then only they will make a contract. In a contract, obligation is founded on the consent of the party. Means consent is must, and consent is the essence of the contract. Otherwise, there is no contract at all. In torts, fourth, in torts, mistake is no defense. And even if it is innocent also, if he enters B's house by mistake, action lies in tort for trespass. Mistake is not an excuse in the tort, but in the contract. A contract entered into by the mistake is wide, but mistakes of law, one's own country, no defense, or everybody is supposed to know the law of the land. But mistake is a bit considered in the contract, but no such a thing would be there in the tort. And in tort, the fifth one, in tort is a violation of the infringement of the right in rem. That I told you that nobody should have to beat you. Hence, right against the world. That is called right in rem, we will say. But here in the contract, it is a particular person would be there. That's why we can say right in personam, means particular person. So in case of the contract, it is a violation of the right in personam. There is a right available and enforceable against a particular persons. That is the fifth one. Then the sixth one comes over there is in the case of a tort, the duty is fixed or imposed by law and is owned to the community at large. Yes, the duty is imposed by the law, operation of the law, or fixed by the law, or a common law duty, we will find in the tort. But here, the parties will agree for the terms and conditions of the duty and the rights, and they are fixed by them only. Still 5 minutes are left over there. Then, and when we come to the sixth point is concerned, in case of a tort, the duty is fixed or imposed by the law. Of course, just now we did it. Is owed to the community at large. Even a community at large also owed to it, because generally there should be norms are there, customs are there, usages are there. They will be prevailing in the common law, and that is the tort law. But in the contract, it is agreeable by the parties only what to do and what not to do. In number seventh, in torts, motive is often taken into consideration. Yes, motive is an important or not, you have taken into consideration. I don't know whether you remember it or not. When I was teaching the law of tort, there is some case lies there that Hollywood Silver Fox versus Met. There is a case
Sir,
law.
repeat, sir. Sir, repeat, sir.
If the motive is an important factor in the tort, there is a case law is that Hollywood Silver Fox versus Met case law, where a person is firing and firing at the time when the victims are at the mating season, they could not mate properly. That's why the offspring will be down. At that instant, the motive is taken into consideration. So this case law that we taught, the motive is relevant over there. And another case law also I dealt it. I have forgotten the name of the case law, but the case law facts, a teacher is giving the music lessons to the students, but at the same time the adjacent fellow is beating his utensils and causing the nuisance to the teacher, not allowing to teach the lessons to the students. Then the motive is considered over there, and hence it is the injunction will be given over there. When the classes are going on, music classes are going on, and you neighbor, you are not supposed to produce any sound which will disrupt his studies. So that was the thing where the motive will be taken into consideration sometimes. But in a contract, the motive for the breach is immaterial. Whether you have the motive, you don't have the motive, it is immaterial in the when the breach has occurred over there in the contract. Then the eighth point again we repeat in torts, the damage awarded by the are real or exemplary or unliquidated damages. I already told you that damages are not fixed in the tort. That's why we'll say the unliquidated damages. But in the contract, damage will be ascertained and agreed upon the parties only. That's why we can say it's the liquidated damages. And the ninth point is the period of limitation in case of the usually runs from the date of when the damage is suffered. Whenever the damage is occurred over there, for the limitation period will start from the damage. When it comes to the contract is concerned, the period of limitation means from the date of the breach. When the date of the breach was there, from there the limitation period will start. So, of course, there is a light distinction between the tort and breach of trust because generally that we don't expect such a question in the examination because it is nothing but a breach of trust is nothing but in one way, in another way is a contract. But only the trustees will depend upon the equity principles are there that we have to keep in the mind. And when you come to the quasi contract is concerned, of course, the quasi contract is it is the equity contract should be there, and where it is also personam is there in the equity contract, and the tata right in rem is there. So as usually these are the things which will come across when you say the tort, and mostly the questions will be asked in the examination is tort and contract, tort in crime. But less we can see it. Suppose if they ask the what is the distinctions are there for the long question at the time that you can write the tort, contract, tort, crime, tort, cause a contract, tort, breach of trust. So these are the things you have to do it when you are writing the examination. So in this class we have successfully completed what? Tell me.
Tort, and then the difference between the tort and the contract, and the difference between the tort and the crime, and the that is the another question of quasi contract.
Yes, yes, yes.
Tort and quasi contract, sir.
Yeah, these are the things which are there. But in the next class, we will see that better. We can see the demnum sine injuria and injuria sine demnum. Please, you read and come to the class tomorrow, and we also deal with it. UB just EB remedium. UB just EB remedium. This is the another maxim. Where there is a right, there is a where there is a where there is a right, there is a remedy. That is UB just EB remedium. Where there is a right, there is a remedy. So these are three things we will try to make it out with the decided cases. But generally, before of course, now it is